Assalamualaikum warahmatullahi wabarakatuh. My name is Patricia binti Muhammad Firdaus and my matrix number is 1250757. So today I will be presenting a legal case review on VIRAN anak lelaki NAGAPAN versus DEEPA anak perempuan SUBRAMANIAM with the Attorney General and others. This case reported in 2015, 3 MLJ2009 deals with an important issue of jurisdictional conflict between the civil courts and the Sharia courts in Malaysia. First of all, I will introduce a little bit about the case. So this case involved a civil marriage between VIRAN and DEEPA under the Law Reform Marriage and Divorce Act 1976. In 2012, the husband, which is the VIRAN, converted to Islam and subsequently applied for the dissolution of the marriage and custody of the children in the Sharia High Court. Meanwhile, the wife, which is DEEPA, filed for divorce and sub-custody of the children in the Civil High Court, raising the issue of a potential conflict of jurisdiction between the civil and Sharia courts. So the main question in this case whether the civil courts or the Sharia courts have authority over matters relating to children of a civil marriage when one spouse converts to Islam. Next, we move to the objective of the case. So the objective of this case review are first, to understand the jurisdictional conflict between the civil and Sharia courts. Second, to examine the civil court's authority over civil marriage even if one spouse convert to Islam. Third, to evaluate how custody orders are decided with a focus on the welfare of the children. Fourth, to assess the validity and implication of recovery orders when there are conflicting court decisions. Next, we move to the facts of the case. So here are the key facts of this case. First, VIRAN and DEEPA had a civil marriage in 2003 and had two children, which is Shamila, the daughter, and Mitran, the son. In 2012, VIRAN converted to Islam and also registered the conversion of his two children. He applied for dissolution of the marriage and custody of the children at the Sharia High Court. The court initially granted temporary custody, then permanent custody to VIRAN while allowing DEEPA visitation rights. In December 2013, DEEPA filed for divorce and custody in the Civil High Court. The court granted her both and the children were handed over immediately. 2 days later, VIRAN took Mitran from DEEPA, leading her to apply for a recovery order under Section 53 of the Child Act 2001. The High Court granted the recovery order and the Court of Appeal upheld it. VIRAN's appeals were ultimately dismissed. Next, we move to the important part, which is the legal analysis. So the first one is the issue. So the first issue is whether the Sharia court has jurisdiction to hear and determine matters relating a non-Muslim marriage. Second, whether the High Court had the authority to hear and decide the case. Third, whether a decision by the Sharia court could be set aside by the High Court. And the next one is rules. The rules that used in this case is first, Law Reform Marriage and Divorce Act 1976. Civil courts have jurisdiction over civil marriage, including divorce and custody. Second, Federal Constitution Article 121 Clause 1A stated that civil courts have no jurisdiction over matters within Sharia court's authority, but this does not remove jurisdiction over civil marriage. Next one is Section 53 of the Child Act 2001, that courts may issue a recovery order if a child is taken without consent from the person with lawful custody. And the last one is precedent case, which is case Subashini anak perempuan Raja Singam versus Saravanam anak lelaki Tangga Torai 2008 2 MLJ2013. Stated that conversion to Islam does not remove the civil court's jurisdiction over civil marriage matters. So the last one is the decision. The High Court had jurisdiction over the divorce and custody as this was a civil marriage. Next, the Sharia court had no jurisdiction over non-Muslim civil marriage matters. So Article 121 Clause 1A did not prevent the High Court from acting. The recovery order under Section 53 of the Child Act was valid. So the appeals against both the custody and recovery orders were dismissed. Next, we move to discussion about this case. There was a conflict between the custody orders of the Sharia court and the civil high court. The husband got custody from the Sharia court after converting to Islam, while the wife later got custody from the civil high court. The court clarified that civil courts have jurisdiction over civil marriage, even if one spouse converts to Islam. Article 121 Clause 1A does not remove this authority, so that the welfare of the children was the main focus. Custody decisions must ensure the children's safety, well-being and stability. So that Section 53 of the Child Act allows recovery only when lawful custody is prevented. Last but not least, I will do a simple conclusion about this case. This case highlights three main lessons. First, civil courts retain jurisdiction over divorce and custody matters arising from civil marriage, even if one spouse converts to Islam. Second, custody orders by the Sharia court cannot override or conflict with the civil court decision for children of a civil marriage. Third, the welfare of the child is always the court's primary concern, and legal provisions like Section 53 of the Child Act must be applied carefully in cases of conflicting orders. That's all from me. Thank you.